What Landsberg Prison feeds inmates today versus its dark 1924 past. The kitchen supervisor put down her clipboard and read the delivery manifest a second time. The numbers were the same. They had not changed. And if they were correct, something had been happening inside Landsberg Prison's food supply chain for at least 6 weeks that nobody in the administration had flagged, questioned, or reported. Stay with this story, because what she found next had been documented and ignored twice before. Landsberg am Lech is a small Bavarian town in southern Germany, approximately 65 kilometers west of Munich. Its prison, Justizvollzugsanstalt Landsberg, has operated continuously since 1909. It is one of the oldest functioning correctional facilities in the Federal Republic of Germany. Most people who know the name know it for one reason. Between November 1923 and December 1924, Adolf Hitler served a reduced sentence there following the failed beer hall putsch. During that confinement, he dictated the manuscript that became Mein Kampf. The room where he worked has been documented, photographed, and studied by historians for decades. The prison did not close. It did not become a museum. It continued operating as a functioning correctional facility, holding sentenced inmates under the jurisdiction of the Bavarian State Ministry of Justice. Today, Landsberg houses approximately 600 inmates. It operates under the modern German correctional philosophy, a framework built on rehabilitation, structured daily routine, and nutritional standards that are among the most rigorously defined in the European Union. What the delivery manifest in the kitchen supervisor's hands suggested was that those standards had not been met. Not recently, and not for the first time. Her name was Ingrid Hoffmann. She had worked in institutional food service management for 19 years, the last 7 at Landsberg. She was not an investigator. She was not an auditor. She was the person responsible for ensuring that what arrived at the loading dock matched what had been ordered, and that what was prepared in the kitchen met the nutritional specifications required by Bavarian correctional regulations. She was good at her job. Precise. Methodical. The kind of professional who noticed when a column of figures didn't resolve the way it should. What she was looking at on the morning of March 14th was a 6-week pattern of protein content substitutions in the facility's primary meat supply contract. The substitutions were within the contractor's permitted variance range, technically. Each individual week's delivery would have passed a standard compliance check without a flag. But 6 weeks in sequence told a different story. Accumulated across the full period, the protein shortfall across the inmate population was significant enough to push the facility's average daily nutritional provision below the minimum threshold required by EU Directive 2013/33 on reception conditions, a standard that applied to detained persons across member states. Individually compliant, collectively non-compliant. It was the kind of gap that only appeared if someone looked at all 6 weeks at once. Hoffmann had seen a version of this pattern before. Twice. The first time had been at a different facility, before her tenure at Landsberg. She had flagged it to her supervisor, been told the variance was within acceptable parameters, and the matter had been closed. The second time had been during her 3rd year at Landsberg. A similar substitution pattern, shorter in duration, caught early enough that she had reported it verbally to the facility's procurement officer. The contractor had adjusted the following week's delivery. No formal report had been filed. Both times, the pattern had stopped. Both times, no one had asked why it had started. Now it was happening a 3rd time. And this time the duration was longer, the accumulated shortfall was larger, and Hoffmann had recently become aware of something she had not known during either of the previous incidents. There was a second set of records she had never been given access to. Delivery records maintained not by the facility's internal kitchen log, which she managed, but by the contractor's own dispatch system. She had learned of their existence 3 days earlier, by accident, during a routine conversation with a loading dock worker who had assumed she already knew about them. She had not. When she requested access that morning, she was told the records were proprietary to the contractor and not subject to internal facility review. She filed the access request in writing anyway. The written denial arrived 4 hours later. But when she cross-checked the denial timestamp against the contractor's most recent delivery log entry, everything changed. The denial had been timestamped at 11:47 a.m. The contractor's most recent delivery log entry, the one Hoffmann had been cross-checking when the denial arrived, was time-stamped at 11:43 a.m. 4 minutes before the denial was issued, someone had updated the delivery record. Hoffmann sat with that for a long time. She was not a suspicious person by nature. 19 years in institutional food service management had made her precise, not paranoid. She looked for gaps in numbers, not motives behind them. But a delivery record updated 4 minutes before an access denial was issued was not a gap in numbers. It was a sequence. She printed both timestamps. She placed them side by side on her desk. She wrote the 4-minute interval in the margin of her notepad and underlined it once. Then she did what her professional instinct told her to do before doing anything else. She went back to the beginning. The Landsberg food service contract had been held by the same private contractor for 11 years. The contract had been renewed 3 times without competitive rebidding, each renewal processed through the Bavarian State Procurement Office as a standard continuation agreement. Hoffmann had not been involved in any of the renewals. That was outside her operational scope. Her responsibility began at the loading dock and ended at the serving line. But the procurement files were not classified. They were administrative records, accessible to senior facility staff upon request. Hoffmann had never requested them before. She requested them now. What she found in the procurement file was not irregular on its surface. Standard contract language. Standard variance provisions. Standard renewal documentation with the required ministerial signatures. But on page 7 of the most recent renewal agreement, there was a clause she had not seen in institutional food service contracts before. The contractor was permitted to substitute protein sources within a defined quality tier, provided that weekly delivery weights met the specified minimums. Weight minimums, not nutritional content minimums. The distinction was precise and deliberate. A delivery could meet its weight requirement exactly while falling below its protein content threshold, if the substituted ingredient carried less protein per gram than the original specification, which was exactly what the 6-week pattern showed. The contractor had not violated the contract. The contract had been written to allow what the contractor was doing. Hoffmann stared at page 7 for a long time. She thought about the 2 previous incidents. The substitution patterns that had stopped without formal investigation. The verbal report she had made 3 years earlier that had produced a corrected delivery the following week and nothing else. She wondered whether whoever had adjusted that delivery had done so because the pattern had been flagged, or because the pattern had reached a threshold that triggered an internal contractor review she had never been told existed. She had no way to know. The records that would have answered that question were proprietary. She escalated formally for the first time. She prepared a written summary of the 6-week pattern, the accumulated nutritional shortfall calculation, the EU Directive threshold breach, the procurement clause on page 7, and the 4-minute timestamp sequence. She submitted it to the facility's Deputy Director of Operations with a request for an independent nutritional audit. The Deputy Director acknowledged receipt the same day. His response arrived the following morning. It noted that the contractor's weekly deliveries had met all contractual weight requirements. It noted that the variance provisions in the renewal agreement had been reviewed and approved by the Bavarian State Procurement Office. It noted that Hoffmann's nutritional shortfall calculation, while noted, was based on an EU directive that applied to immigration reception facilities rather than sentenced prisoner institutions and therefore did not constitute a binding compliance standard for Landsberg. The response was 3 paragraphs long. It did not address the 4-minute timestamp. It did not address the updated delivery record. It closed by thanking Hoffmann for her diligence and noting that the matter had been reviewed and resolved at the operational level. She read the response twice. The EU directive citation was not wrong. The directive did technically apply to reception conditions rather than sentenced facilities. It had been the closest applicable standard she could cite. The actual sentenced prisoner nutritional framework under Bavarian correctional law used less specific language that gave facilities considerably more interpretive latitude. Whoever had written the deputy director's response knew that. They had known exactly which thread to pull to make the formal complaint structurally insufficient. Hoffmann was not finished. But the next step she was considering was outside her operational authority. It involved contacting the Bavarian State Ministry of Justice directly, bypassing the facility's internal chain entirely. That was not a step taken lightly inside a state correctional institution. It carried professional consequences that she had spent 19 years carefully avoiding. She spent that evening reviewing the EU Nutritional framework documents she had downloaded from the European Commission's public database. She was looking for a standard, any standard, that applied unambiguously to sentenced prisoners in German federal state facilities. At 11:20 p.m. she found it. Not in the EU directive she had originally cited. In a 2019 amendment to the Bavarian Correctional Facilities Act that had been passed quietly during a legislative session with minimal public attention. The amendment had introduced a binding minimum nutritional provision standard for all sentenced prisoners in Bavarian state facilities. It had come into effect on January 1, 2020. The 6-week substitution pattern had begun on February 3, 2020. 33 days after the amendment became law. The contractor had been operating below the new binding standard from the first week it had been legally enforceable. And somewhere in the facility's administrative record, there was a contract renewal that had been processed and signed, with the wait-only variance clause intact, after the amendment had passed. The renewal was dated November 2019, 6 weeks before the amendment came into force. The clause that allowed what the contractor was doing had been locked into the contract one legislative session before the law changed to make it non-compliant. That was not coincidence. That was timing. And the person who needed to hear what Hoffmann had found was no longer inside the facility's chain of command. The Bavarian State Ministry of Justice received Hoffmann's formal submission on a Thursday morning in late March 2020. It was 8 pages. Methodical. Chronological. Every claim supported by a document reference. Every document reference accompanied by a page number and a timestamp. 19 years of precision, assembled into a single filing. The ministry assigned it to an internal compliance review officer within 48 hours. That was faster than the standard processing window. Hoffmann noted the speed without drawing a conclusion from it. The review officer's name was Stefan Brauer. He was a mid-level administrative lawyer who specialized in correctional facility procurement compliance. He had handled similar filings before: contract disputes, supply chain irregularities, vendor performance complaints. He had not handled one with this particular combination of elements before. Brauer requested the full 11-year contract history from the Bavarian State Procurement Archive within his first week on the file. Standard procedure for a vendor performance review. What came back was standard in volume and irregular in one specific detail. The contract had been renewed 3 times. The first renewal had gone through competitive rebidding, as required by state procurement law for contracts exceeding a defined annual value threshold. The second and third renewals had not. Both had been processed as continuation agreements, a classification that exempted them from competitive rebidding requirements under a procurement law provision designed for low-value, low-risk service contracts. The Landsberg food service contract was neither low-value nor low-risk by any standard definition. Someone had classified it as both. Brauer pulled the classification approvals for the second and third renewals. Both had been signed by the same procurement officer, a man who had retired from the Bavarian State Procurement Office in 2018. A man who, Brauer discovered through routine background verification, had accepted a consultancy position with the contractor's parent company 6 months after his retirement. The consultancy was legal. The cooling-off period under Bavarian civil service regulations at the time required only a 3-month gap between public service departure and private sector employment in a related field. He had waited 6 months. Double the requirement. Clean on paper. Brauer documented the connection. He noted it did not constitute evidence of corruption under the applicable legal standard. He noted it did constitute a conflict of interest that should have triggered an independent review of the renewal classifications at the time they were processed. No such review had been conducted. No such review had been requested. The 2 continuation agreement classifications had moved through the procurement office without a flag. The full review findings were published by the Bavarian State Ministry of Justice in September 2020. The document ran to 34 pages. Its language was administrative and precise. Its conclusions were not mild. The weight-only variance clause in the food service contract was found to be non-compliant with the 2019 amendment to the Bavarian Correctional Facilities Act as of January 1, 2020. The contractor was formally notified of the breach. The contract was amended within 60 days to replace the weight-only variance provision with a nutritional content minimum standard aligned with the new legislative requirement. The second and third renewal classifications were found to have been processed without the independent review that the contract's value and risk profile required. The Procurement Office's classification guidelines were revised. A mandatory independent review threshold was introduced for all correctional facility service contracts exceeding a defined annual value. The retired procurement officer's consultancy relationship was referred to the Bavarian State Ethics Commission for review. The Ethics Commission concluded that no legal violation had occurred under the regulations in force at the time of his appointment. The matter was closed. No criminal charges were filed against any individual. Hoffmann received a formal acknowledgement letter from the ministry in October 2020. It thanked her for her submission and confirmed that her filing had initiated the review process. It did not describe the findings in detail. It did not address the 4-minute timestamp sequence she had documented in her original submission. That specific element, the delivery record updated 4 minutes before the access denial was issued, appeared once in Brauer's internal review notes as an item requiring clarification and did not appear again in the published findings. The clarification, if one was ever obtained, was not made public. Landsberg Prison operates today under the revised contract standard. Inmates receive meals that meet the nutritional minimums introduced by the 2019 legislative amendment. The food program is monitored under the revised procurement framework that Hoffmann's filing helped produce. The kitchen is functional. The standards are documented. The oversight is structured. By every current metric, the system is working. But the 11-year contract history that Brauer's review uncovered raises a question that the published findings did not fully answer. The two previous substitution patterns, the ones Hoffmann had observed and reported verbally, the ones that had corrected themselves without formal investigation, now sat inside a documented timeline showing that the weight-only variance clause had been in the contract since the second renewal, which meant the contractor had operated within a clause that permitted nutritional substitution for years before Hoffmann ever noticed the first pattern. The previous patterns had not been anomalies. They had been the contract functioning as written, and the contract had been written that way, or allowed to remain that way, through 2 renewal cycles, by a procurement process that bypassed the independent review that should have caught it, approved by an officer who would later work for the contractor's parent company. None of that was proven to be deliberate. None of it met the legal threshold for the finding of wrongdoing that would have produced consequences beyond a revised guideline and a closed ethics referral. But the timeline existed. It was documented. It was public. And Landsberg Prison, a facility whose most infamous former occupant understood precisely how institutions could be used, how processes could be navigated, and how paperwork could be made to say one thing while something else entirely was happening, had spent 11 years feeding its inmates under a contract that the people responsible for reviewing it had chosen, twice, not to put out for competitive bid. The building is still there. The kitchen is still running. The standards are better now than they were. The question of how long they will stay that way depends entirely on whether the people responsible for the next renewal remember what happened the last time no one was watching. History does not require dramatic villains. It requires ordinary processes, applied without sufficient scrutiny, repeated often enough that the gap between what the paperwork says and what is actually happening becomes too wide to close quietly. Landsberg has seen that pattern before. In a different era. In a different context. With consequences that were not administrative. That is not a comparison. It is a reminder. Institutions are only as reliable as the people willing to read the documents nobody asked them to read. Ingrid Hoffmann read them. This time, that was enough. The next time, it may depend on whether anyone else does. Ingrid Hoffmann returned to work on a Monday morning in November 2020. The revised contract had been in effect for 6 weeks. The new nutritional content minimums were being met. The compliance monitoring framework was operational. From the outside, The system looked exactly as it was supposed to look. She knew better than most what that meant and what it didn't. The procurement guideline revisions introduced after the review had closed one specific gap. Correctional facility service contracts exceeding a defined annual value threshold now required independent review at each renewal cycle. The classification exemption that had allowed 2 continuation agreements to pass without scrutiny had been removed from the applicable provision. It was a precise correction. Targeted. Effective within its defined scope. What it did not address was the 11 years that had preceded it. 3 weeks after the published findings were released, Hoffmann received a call from a researcher at Ludwig Maximilian University in Munich. A doctoral candidate in public administration named Markus Fehler who had been tracking German state-level correctional procurement practices for his dissertation. He had read the ministry's published review. He had read it carefully. He had one question. The 2 previous substitution pattern incidents, the ones Hoffmann had referenced in her original submission, had they ever been formally documented anywhere in the facility's internal record? Hoffmann was quiet for a moment. The answer was no. The first incident had been raised and dismissed verbally at a different facility. The second had been reported verbally at Landsberg and corrected without a written record being created. Neither had generated a document that could be retrieved, reviewed, or included in the ministry's 11-year contract audit. They existed only in Hoffmann's memory and in the pattern she had recognized the third time because she had seen its shape before. Fehler noted this carefully. Then he told her what he had found in his own research. Across 7 Bavarian state correctional facilities over a 15-year period, Fehler had identified 9 separate instances of food service contractor substitution patterns that had been corrected without formal documentation. In every case, the correction had occurred after a verbal report from kitchen staff. In every case, no written record had been created. In every case, the contractor had continued operating under the same contract terms that had permitted the substitution. 9 incidents. 7 facilities. 0 formal records. The pattern at Landsberg had not been unique. It had been routine. Fehler published his dissertation findings in 2022. A summary was picked up by 2 German public administration journals. It recommended a mandatory written documentation requirement for all food service substitution corrections at Bavarian state correctional facilities, regardless of whether the correction was made voluntarily by the contractor or in response to a staff report. The recommendation was under review by the Bavarian State Ministry of Justice as of the most recent published status update. It had not yet been adopted. Hoffmann still works at Landsberg. She still manages the loading dock manifest every morning. She still checks the delivery figures against the nutritional specifications. She still notices when a column of numbers doesn't resolve the way it should. The difference now is that when she files a written report, there is a defined escalation pathway, a named review officer, and a mandatory response timeline. The system that exists today is better than the one she worked inside for 19 years. Whether it is good enough depends on the next person who decides, as she did, that a number worth noticing is a number worth writing down. That decision cannot be legislated. It can only be made by the individual standing at the loading dock with a clipboard, reading the manifest a second time. Some systems change because they fail dramatically. This one changed because one person refused to stop counting. If this story stayed with you, the next one goes further, and the documents are even harder to find.